Good morning, everybody. Doing business using social media and in e-commerce involves various intellectual property rights. So we'll look at how that is addressed in various social media platforms. What is infringement? It's basically using any of the intellectual property rights that you just heard about, such as trademarks, copyrights, patents without consent or permission from its owner. The main social media platforms are Facebook, Twitter, Snapchat, TikTok, and Instagram. In these platforms, online infringement can take many different forms. Examples of infringement include use of same or similar trademarks or logos. For example, if someone is using a confusingly similar logo as yours, then that's potentially infringement. Use of photographs or images owned by others. Examples are pictures on your website if someone copies them or takes them and puts them on their own website or copies your ads. Another is use of content or written materials owned by others. If somebody writes up something on their website and that's taken and used without permission or consent. Another form of infringement is use of trademarks in domain names or social media names or handles. Impersonating a trademark owner's website or social media pages, selling counterfeit or infringing products. So how do you enforce IP rights? The simplest avenue is to report violations using the social media's platform infringement reporting or complaint system. However, even if you're successful in taking down an infringing post, that person or the infringer will not, or the owner will not be entitled to additional remedies, such as recovery of money or obtaining a mechanism that would prevent the infringer from reposting the infringing post, such as a court injunction. So even if a post is taken down after a complaint is filed with a platform, there's nothing preventing the infringer from reposting on another social media site. The IP owner would have to go to court to obtain a monetary recovery or to obtain what we call an injunction. Also, social media platforms do not adjudicate disputes between third parties. So they're not in a position to act on infringement reports that require an in-depth intellectual property analysis or reviewing facts in a real world dispute outside of the social media platform. So in certain situations, rather than contacting the social media platform or making a report, you may want to reach out directly to the party that you believe is infringing. So sometimes it's better for your PR or public relations that you engage in a friendly conversation with the infringer that could prevent a negative social media campaign against your company or your company name and your trademarks. So that's something important to consider. However, in other situations, when there's widespread infringement, or if it's causing harm to your brand name or reputation, then court action should be considered, or formally sending what we call a cease and desist letter. In addition, of course, to reporting violations through the social media reporting process. So Facebook, Twitter, Snapchat, TikTok, they've all developed their own reporting procedures. A person reporting infringement should expect to provide details of any relevant trademark or copyright registrations, what Ms. Kim talked about earlier, obtaining trademark or from the U.S. Patent and Trademark Office or a patent from the same office. So if you have a registration, certificate or a number, then that would be an information that you should be providing to these sites. You should also include a brief explanation of how the reported content is infringing your rights. So let's go. I'm just going to quickly go through these slides. This is all the links to these screenshots are available through each of these sites. So let's start with Facebook. So according to Facebook's Help Center, if an IP owner believes content on Facebook infringes its copyright or trademark, for example, if someone stole a photo of your product or an ad on your Facebook page without any attribution to you, or if someone is using your business name without your authorization, one or more of the following actions can be taken. You fill out a form, you contact the designated agent, or you resolve the issue without contacting Facebook by sending a message directly to the person who posted the content. The link to the copyright report form is on the Facebook website. Once you click on the link, you first pick from the list of options as to what best describes your issue. You can see here what these options are. Of course, you have to provide information regarding your copyright and what you're reporting. So if you have a registration, you provide that information as well. Lastly, Facebook will ask that you sign a declaration statement, which requires you to attest to the accuracy of the provided information under the penalty of perjury. This is basically to discourage false claims. Same thing with the trademark infringement reporting process on Facebook. You have to go through the form, identify what type of infringement you're reporting. And again, you have to sign that you're providing the information under the penalty of perjury. So Instagram, that's owned by Facebook. It basically has very similar reporting requirements. Let's now talk about Twitter. So reporting copyright infringement on Twitter, you fill out the copyright infringement report form. So you must provide information about your copyrighted work, whether it's a photograph, your music, or a portion of a book that you wrote, or a portion of a description or a write-up that you have on your website. So this includes a description of what's copyrighted, where it appears, where the tweet appears. You have to provide the URL or the link to the tweet. And just like Facebook, Twitter will also ask that you provide a statement which requires you to attest to the accuracy of the information you're providing under the penalty of perjury. And same thing with trademark infringement. You have to go through the same process. You provide information about your trademark, what you own, your registration, and as well as the infringing tweet. For Snapchat, I mean, there are several forms to report infringement. You have copyright, trademark, and right of publicity. Right of publicity it's often called, personality rights. So it's a right of an individual to control the commercial use of his or her name, image, likeness, or aspects of one's identity. Basically, you cannot post content that infringes on a person's right of publicity, or force a person to allow use of their name, image, or likeness. Actors, famous people, including well-known TikTokers, Instagrammers with a lot of followers. I mean, they own rights of publicity in their image, but you don't necessarily have to be famous to own your right of publicity. So that's what that is here. So again, you must select the type that you're reporting, provide your information and information on what you're reporting. And again, you have to sign a declaration under the penalty of perjury that you're authorized to act on behalf of the owner, and that you are providing correct information. And this is the trademark infringement form on Snapchat. And again, you have to provide information about what you're reporting as infringing and what rights you own. So for TikTok, it's similar. You must also provide information about yourself, your contact information, and also copyright ownership. What you own, and if you have a registration, you have to provide that information as well. And same thing with a trademark. And you also again have to sign a statement that you have a good faith belief of what you're complaining about, and that you, under the penalty of perjury, that you're the trademark owner or an authorized to act on behalf of the owner. So the takeaway from all of this is IP enforcement in social media is really important because it'll preserve your brand name and business. However, if there's any infringement of your rights, it's always better to try to resolve the infringement directly with the person or entity violating your IP rights. If you cannot do so, you just proceed with the various reporting forms available on these platforms. But remember, in order to take advantage of these reporting procedures, you have to be the IP owner or the owner's agent or an authorized representative of the owner. So next, let's look at Amazon's brand registry program. Ms. Yan mentioned that in her presentation. It's basically, sellers who produce and sell their own private label products on Amazon should sign up for Amazon's brand registry program. We regularly help Korean business, and these are ranging from individuals to medium-sized businesses to even large companies with their trademark application process, which helps them participate in the Amazon brand registry program. This program is available to sellers who manufacture or sell their own branded products. So manufacturers can enroll the brand in the Amazon registry program and register themselves as the brand owner. So the goal of this program is to make it easier for sellers to manage their own brands and list their products on Amazon. So benefits include allowing a brand to have complete control over the product listings. Also, to ensure that information given about a product is accurate. It helps to increase product sales by facilitating a more streamlined process in removing fraudulent or infringing or counterfeit product listings. It also helps protect your brand. So the requirements, registered trademark, I believe that they changed that in November of 2020. So now it's a pending trademark registration with the USPTO. And it's with certain, or with the USPTO or certain countries. Basically for the trademark, you have to have a word mark. So it can't be a logo. It has to have a word. So what you need to provide, you have to provide your serial number from the issued, or that was issued by the US Patent and Trademark Office. You also provide images of the brand's logo, you know, where the word mark appears. And if you have a logo accompanying it, that's fine, as long as you have the word mark. Images of the products that carry the name. And if the name is not on the product, you know, packaging, a photograph of the packaging is fine. A list of the product categories of what you're going to be selling or what you're selling. A list of countries also when they're where the products are manufactured and distributed. So once you've provided all this information, you can just go ahead with the Amazon brand registry program process. Another, you know, in e-commerce for patent infringement, court proceedings for patent infringement are quite expensive. So Amazon provides a way to address that in a more efficient manner and a much cheaper manner too. So in general, social media platforms provide avenues for copyright and trademark infringement, which is what we looked at earlier with all these different platforms and their forms. But that doesn't, if you notice, that doesn't include patent infringement, because patent infringement is more fact intensive. It basically requires an infringement analysis looking at the patent claims and comparing the patent with the product that's infringing to make sure that there's a one-to-one correlation. So that's more fact intensive, and none of these social media platforms will really do that or engage in that. So Amazon, although it's not a social media platform per se, it has a process of dealing with patent infringement. So if Amazon sellers are infringing your utility patents, and this is this only applies to utility patents, you should consider this Amazon Utility Patent Neutral Evaluation Program. Through this program, you can have listings for infringing products removed. So to initiate this, patent owners must file an infringement report through the Amazon website. And once the patent owner has submitted the form, Amazon will contact the accused sellers and invite them to participate in the evaluation process. If the infringing seller fails to participate, then Amazon will just remove their listings. So the process is relatively quick. From beginning to end, it takes about 2 to 3 months. It's cheap, it's $4,000 for each party, and that is refunded to the winning party. It's very straightforward. Basically, the patent owner, you file a brief explaining why you believe that the product is infringing, and then you're also allowed a reply brief. The seller, the infringing seller, is allowed a 15-page opposition, and basically that is a very streamlined process to address infringement on e-commerce, particularly Amazon. So, I mean, in sum, the Amazon utility patent evaluation procedure, it provides a very fast and effective and affordable way for patent owners to deal with their rights and to enforce them against online infringers. So that concludes my presentation, and I'll go ahead and introduce the next presenter, Mr. Roberto Martinez. He's a Google digital coach and the CEO of Braven Agency.